Greetings. In this episode, we're going to look at the federal court system. So let's start out with the role of the courts. The federal courts aren't really created by the Constitution. They come a little bit later, and they're created through the Judiciary Act of 1789. In the Constitution, it says that Congress can establish a judicial branch, so they do so in this act. Now, the purpose, of course, of the judiciary branch, the courts, is to ensure that laws are enforced fairly, and then also to interpret the laws. Is the law constitutional? And of course, that's going to be the job of the Supreme Court. Now, our federal court system is layered. It has three different layers. At the bottom layer, we have over 94 district courts. These are where actual trials are had. The step up is what's called a circuit court, and these are appeals courts. They don't really have a trial. They're looking to see if what the district court did was right or wrong, were the rules followed. And above that is the Supreme Court. And of course, we only have one. And this was where the appeals process ends. So we also, on top of that, because our system is set up with separation of powers, we have what's called a dual court system. We have both a federal and a state version. And because there's two of them, it's called dual. The state courts, of course, enforce state laws, and the federal courts enforce federal laws. Now, every once in a while, we have something that kind of crosses over, and it's carried by both sides. And we'll talk more about that as we go through this video. Now, when it comes to the differences between state and federal courts, there's a lot of similarities. If you look at this graphic, with the federal court, we have the three levels: trial courts, appeals courts, and the Supreme Court. So all this is derived from the U.S. Constitution and federal law. They hear cases that involve, guess what, federal law. Most of these judges are appointed for life. And at the top of the heap, we have the Supreme Court that can hear appeals from the state Supreme Courts as well. On the state side, we have, of course, three more levels: a trial, appeal, and a supreme. These, depending on what state you're in, these names are different. They get their power from a state constitution and state laws. They hear cases involving state law. Now, here is a difference between the two systems. Most of the judges at the state level are elected or appointed by the governor for a specific amount of time. They're not there for life. In state appeals courts, again, never hear cases that originate in federal court. So if you're arrested for a federal crime, it's never going to make it through the state courts. Now, we'll also look at the blue boxes. You'll see different kinds of cases. And we'll go into this more in detail as well. Jurisdiction. This is how we decide if it's going to be a federal case or a state case. Article 3 of the Constitution gives federal court jurisdiction or authority only to hear certain kinds of cases. Again, this goes back to a separation of powers. The Founding Fathers did not want the federal government to have all the power. They wanted it shared between the states. So this is one of those separation of powers issues, how they set it up to make sure the federal government isn't too strong. Now, when it comes to the case, there's a list of things that have to be the crime has to fit this list in order to be a federal court system case. So it has to do with the U.S. Constitution or federal laws. So some examples of that would be tax evasion, like you're not paying your income tax to the federal government. Or if you kidnap somebody and go over a state border, that would be a federal crime. Another one would be a bank robbery. That too is a federal crime. If there's a disagreement between states, if something's happening between Florida and Georgia, or people from two different states are suing each other, then it's going to go to federal court. That way we're not arguing over, oh, should Florida be able to do it in their court or Georgia in their court? It gets kicked up to the federal government. Maritime laws. These are crimes that are committed on the ocean. So think of it this way. If it is a drug smuggler smuggling in drugs from South America via a boat, that would be a federal offense. If it involves the federal government, let's say like a military contractor, a company who's supposed to be providing a service for the military doesn't provide what they promised, that would be the jurisdiction of the federal courts. And if the case has something to do with foreign governments or foreign diplomats, that too is a federal court jurisdiction. So there's two different kinds of jurisdictions as well that we need to look at. Exclusive jurisdiction means that it's only the federal government can try that case, and that is pretty much that list we just went over. Concurrent jurisdiction are where both the state and the federal government can try the case. So a lot of crimes are punishable both at the state and federal level. Things like environmental regulations are concurrent. Civil rights cases, anything involving the Constitution, those are going to be concurrent. At the state level, we're talking about more run-of-the-mill type cases, traffic violations, divorce, you know what I mean, breaking and entering, burglary. Those are, for the most part, going to be at the state level. Now, the way that our federal courts are set up, at the bottom we have what are called district courts. This is the lowest level of the federal system. And they have what's called original jurisdiction. They're the ones that are going to hear a federal case for the first time. We have 94 different courts at the district level spread out across the country. All states have at least one. The larger states have several. So if you look at the map here on the screen, this is Florida's district federal courts, and you can see there's 3 different district courts in Florida, and depending on where you are in the state, it would be a different court. Now these are trial courts, and they actually determine if somebody is guilty or innocent. Witnesses will testify before these courts, and they have juries that reach the verdict. It's not just a judge that says yes or no, guilty or innocent. It is a trial by jury. Now, the next level up is called the Circuit Court of Appeals. And these courts have a lot of different names. Some people will just call them circuit courts, or they'll be called federal appeals courts, or you might hear them be called appellate courts. They're all the same thing. And across the country, there are 13 of them. 12 are given a geographic area. That's what you see in the map. So the state of Florida is in the 11th District Court of Appeals. And that 13th one, you'll see that it doesn't show up on the map anywhere. That's because it's a special one that's for more business-oriented crime. If somebody breaks a patent law, like if you try to copy an iPad as another company, it'll go to this court. If it has something to do with international law or civil cases where you want to sue America, you want to sue the federal government, then it's going to be in this 13th district. So having this circuit court, they have what's called appellate jurisdiction. They only hear appeals from lower courts. That's it. There's no trial, there's no witness, there's no jury, none of that. It's a panel of judges, and they determine if there was any mistakes made at the lower court at the district level. If a person is convicted at a crime and they think their trial was unfair, they can appeal to circuit court. If the government loses, though, they can't appeal. Only the individual citizen, not the government. And that's because of the Bill of Rights. The Fifth Amendment says there's no double jeopardy. You cannot be tried for the same crime more than once. Now, when the court makes up its mind, it's called a ruling. And these rulings are made by a panel of 3 or more judges that are looking at the original case. It's not just one judge. And only lawyers argue in front of these courts, these appellate courts. There's no witnesses brought through. It's mostly just looking at all the paperwork. Once the judges have made their ruling or their decision, it's made by what's called majority vote. So if you have 3 judges, at least 2 would have to decide the same way. Now, they can rule in one of 3 different ways. They can uphold the ruling of the lower court. That means there's no change, and that person's still guilty, still goes to jail. They can reverse the result of the case, where the person would go free, and they're no longer guilty, or they can remand the case. This is basically a do-over. They send the case back to the district court and they do it all over again. If the results are not what the defendant wants, if that person is still not happy, they can try to appeal it to the Supreme Court. Now, when the 3 to 5 judges make up their mind, they have to make what's called an opinion. Basically, it's their decision in writing. And they write an opinion and try to detail what it was they were thinking. They're looking at what other court cases are they basing this on, and they're spelling out their logic behind their decision. And these opinions become precedents. A precedent is when you set an example for future cases. So when they look at the case in front of them, they're going to look at past cases to see if there's any similarities. If they decide on something new, it sets a precedent, and in future cases, that case will be looked back upon. Now, federal judges, their power is spelled out in Article 2, Section 2 of the Constitution. And in that section of the Constitution, the President of the United States is given the authority to appoint federal judges. The check on this power, though, is that the Senate has to approve the judge. Federal judges have a term for life that's called tenure. So the point of tenure, the point of this life term, is so that they don't have to worry about being popular. They can rule in such a way that they think is fair and don't have to worry about elections or being popular in the minds of the people. Now, these district courts also have lots of other people that work in them. Each court has clerks. These are basically research assistants for the federal judges. And it's a big deal to get one of these positions because it often leads to having your own court one day, being a judge yourself. They have legal secretaries and court reporters. They also have what are called magistrate judges. These are lesser judges. They do the day-to-day stuff. They issue court orders and search warrants and conduct what are called preliminary hearings. A preliminary hearing is basically a judge looking at the evidence and saying, oh, I don't think we have enough, we're not ready yet. Or saying, yep, we have your case is good to go, prosecutor, let's move it on. So these magistrate judges are not appointed by the president, they're appointed by the group of federal judges. So they get to pick, the federal judges get to pick who they're going to work with. And they serve on a term for 8 years. That 8 years can be reappointed, though. On top of that, we have United States attorneys. These are the lawyers that represent the government. They are the ones that prosecute the crimes. And it's a big deal to be a U.S. attorney. They, too, like the judges, are appointed by the president and have to be approved by the Senate. Lastly, we have the U.S. Marshals. This is a branch that acts as like the police force for the federal court system. They make arrests, they collect fines. They're the ones that transport convicted criminals from one prison to another or from the prison to the courthouse. They protect the jurors. And lastly, they deliver subpoenas. What a subpoena is a court order to appear in court. That's it for this time. Next, we'll talk about the Supreme Court.